Good morning. Good morning. Okay, you ready?
Yes, sir.
Calling parties on Levine dates. Calling case number 2062611, People versus Levine, Terrence Dates. Defendant is charged with count 1, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Also calling case number 2158343, People versus Levine, Terrence Dates. Defendant is charged with 1 count, stolen property, thieving and concealing a motor vehicle. Defendant is scheduled today for probable cause conferences on both matters.
Okay, hold on one moment before you put appearances on. Thank you so much. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people in case ending in 2611. My P number is 84009.
Good morning.
Good morning, Nicole Sadi, P74238. I represent Mr. Dates, who is present by Zoom from Wayne County Jail.
And please state your name, sir.
Levine Dates.
Okay, and on both of these files, is it general warrants or is Mr. Slusky on one?
Mr. Slusky is on the other one, Your Honor. I will send him a text message to get him on momentarily.
Okay, which one are you addressing? Can you give me the case number?
Yes, ma'am. I'm on 200-626-110.
Thank you. Okay, well, as it relates to that matter, counsel, what's your pleasure?
Judge,
Yeah,
both we're gonna set exams,
I'll call you back.
and I was gonna do, we might want to wait.
Okay.
Hold on.
I call the number, it just goes straight to something.
If everyone could remember to keep their microphones muted, that would be very helpful. And when your case is called, if you are the defendant, or really if you're anyone speaking, please make sure your video is running. You've got background noise, make sure that you're muted when you are not speaking. Ms. Sadi, once again.
We may want to wait for Mr. Slusky. I was gonna make an oral motion to consolidate these cases. We might want to wait for Mr. Slusky's appearance and pass on the matter, since I wanted to address both in the interest of efficiency. We will end up setting both for exams, but.
Well, I think that they are under two different divisions. So you certainly can make a written motion in that regard, but these two prosecutors, if they're going to consolidate, would likely need to speak to their supervisors. So even if Mr. Slusky is, I'm assuming he's on his way, I highly doubt they would have the ability to say, okay, I'll just hand it over to General, or General, okay, I'll just hand it over to Patu. So
Yeah, there's a large number, and I'll be happy to put in a written motion, but
let's just wait. Let's just wait for Mr. Slusky.
Okay.
I did reach out to him, and he indicated he would be here within 2 to 3 minutes.
Call another case.
Should I do another jail or just need? Well, I'll call Mr. Okay. Calling parties on Terrence Adams. Calling case number, I'm sorry. Mr. Adams is in the break. Calling parties on Elijah Johnson. Calling case number 2155330, People versus Elijah Johnson. Defendant is charged with count 1, controlled substance, delivery or manufacture, cocaine, heroin, or another narcotic between 50 to 449 grams. Count 2, and 3. I'm sorry, counts 2, 3, 4, 5, 6, and 7. Weapons, firearms, possession by felon. Count 8. Weapons, ammunition, possession by felon. Counts 9 through 20. Weapons, felony, firearm. Defendant is a habitual offender. 4th offense notice. Defendant is scheduled today for a competency hearing.
Appearances, please.
Morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles, on behalf of my client, that is Mr. Elijah Johnson, who is physically not present in your courtroom. However, I asked the court to waive his physical presence. But Mr. Johnson is present via Zoom. My P number is 64158.
Well, I guess it would depend on what we're going to do here today as to whether or not his presence can be waived. Have you received a copy of the evaluation, Mr. Tuttles?
I did, Your Honor, but I believe it was part of it was cut off. But I did receive a copy of the evaluation, and I believe that they found Mr. Johnson competent. I would contest that, so I would ask for a hearing on that.
Okay, are you, I don't want to put words in your mouth, are you seeking to have an independent evaluation done, or?
Yes, I am, Your Honor, given that they found him competent, and Mr. Johnson is out. He has the wherewithal to pay for an independent, so we don't have to go through going through the motions of having asking the court to pay for it for Mr. Johnson. But yes, I will ask for an independent examination.
All right, so with that being said, I will waive his presence a little reluctantly, but I'll waive his presence here today. I'm certain that you have been in contact with him to the extent that he understands what's going on here. And with there not being a stipulation to the evaluation, and your posture is that you're contesting it and seeking an independent evaluation, do you have a specific time frame that you're seeking to adjourn this to, Mr. Tuttles?
I would anticipate 60 days should be more than enough, Your Honor.
Okay, can I have a 60-day date for which to return?
Okay.
Judge, if I may, was there 3 reports or was there only 2? Because I only received 2.
I only received 1.
I have the criminal responsibility and the Miranda rights one, but I don't have the competency to stand trial one.
Okay, I had a competency to stand trial. I do not have the criminal responsibility, nor do I have a waiver of his 5th Amendment rights.
Okay, I can send these to you, Mr. Tuttles, if you can send me the one you have.
Okay, will do.
Okay.
Okay,
Thanks.
and that's Ripley.
Yes.
Okay, could you tell me again what that date is, the 60-day review date, Mr.?
That's fine. It'll be September 21st.
September 21st, 2021 at 8:30 via Zoom. And I'm assuming that will afford an opportunity for an evaluation, an independent evaluation to occur, and for reports to be generated and disseminated to both prosecution and defense as well as the court. Is there anything further?
Not on behalf of my client, Your Honor.
Mr. Tuttles, can you hear me?
I can hear you. Call me. I'm getting ready to walk into another courtroom. We will talk today. Do not say anything over this Zoom. Oh, I apologize, Your Honor. I did want to address the.
Wait, I'm sorry. Is that Elijah?
Yeah, that's it.
Yes. Yeah, I just asked you to waive his. I just asked you to waive his physical presence. I did say he was available via Zoom, and I do have some.
Sorry, but I was confused by that. I'm sorry. Can you state your name, sir?
Elijah Johnson.
Yeah, that's why I was saying I was reluctant to waive his presence. Just a miscommunication. I'm glad that the record is clear now. Mr. Johnson is present and is hearing what's going on, is privy to what's going on, and that you will be in contact with him so that everybody is on the same page. Yes, Mr. Tuttles, one more thing you wanted to address?
Yes, Mr. Johnson has been on a tether for an extended period of time, and obviously this is due to him being referred and combination of that and COVID. He has not violated his tether in any shape, form, or fashion. He's having some health problems with the tether, it causes some physical problems to his leg. And because he's been on for so long, Your Honor, he has retained counsel. He showed up for his evaluation, all his evaluations. We have no reason to believe that he's posed a danger to society, nor do we believe that he's posed risk not returning. So we're just asking that the tether be removed at this time. And he's obviously paying for the tether every week.
I'm not so certain. Well, the prosecutor acquiesces to that. I'm fine with it, but I think that the tether is most appropriate circumstances. Madam Prosecutor?
Judge, we would object to that, and if you want to order a DSU, we would request that if any bond changes want to be made.
A DSU won't do as much good since he is out. They will not interview him and generate a report if an individual is not in custody. So that's not really an option. The motion has been made, and I certainly, again, have not heard anything that would warrant removal of the GPS tether. If you would like to present something further to the court, documents, etc., we're in a little bit of a sticky situation because now that the competency is being contested, which you're well within your right to do, it is being delayed a further 60 days for that evaluation report to return. But in the interim, I have to make an assessment as to whether or not that GPS tether is appropriate. And given what is before me in the four corners of this file, the GPS tether is appropriate. Now you mentioned some medical issues. Unless you want, you could provide some documentation and come up with something creative that perhaps would be amenable to the prosecution's ears, then I'm here for it. But to just remove Mr. Johnson from a tether, not real comfortable with that.
I got medical reason.
Mr. Johnson, hold on. So, Your Honor, what I do is I submit a formal motion to your court, a written motion to your court, and I would provide the documentation necessary.
Okay, including not just the representation of medical issues, but some sort of confirmation of saying and how that there is interfering with it specifically.
Yes, I will provide that documentation to the court, not just an assertion that is bothering him or is causing health issues. I will provide the appropriate documentation.
Okay, all right. With that being said, I will look for that to appear in my email or otherwise come within the file here. If it's appropriate to do so, we will tee it up for a motion hearing. Otherwise, we've got the September 21st competency review date.
Thank you.
Thank you, Judge. I would just request that whatever motion sent, I be copied onto.
Oh, absolutely. Okay.
Okay. Thank you.
Thank you.
Mr. Johnson, we'll talk today and get that motion together.
Okay, thank you, Mr. Teller. Thank you very much.
You're welcome, Mr. Johnson. It's my job.
All right. Thanks, bro.
Okay.
Calling parties on Sean Chappie. Calling case number 21-57372. People versus Sean Quinn Chappie. Defendant is charged with count 1, home invasion, first degree. Count 2, assault with intent to do great bodily harm, Western murder by strangulation. Count 3, domestic violence. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Your Honor. May it please the court, Roia Epps Ward, P number 84898 on behalf of Mr. Chappie. Mr. Chappie, could you please state your name for the record?
Good morning, Your Honor. Sean Quinn Chappie.
Thank you. Counsel, what's your pleasure?
Your Honor, The last time we were here, the court postponed because we hadn't received all of the discovery. We received the majority of it. I want to thank the court for accommodating us. The only thing we need at this point are the 911 calls. Rather than delay the court any further, I don't have a problem with scheduling the matter for exam with the understanding that the prosecution will turn over those calls to us before that time.
Prosecution?
Yeah, actually, I did request the 911 and I received a response back on June 29th that they could not be recovered because of equipment malfunction. I apologize. I thought I had forwarded that info on to you, Ms. Epps, but that's the response I got. So there are no 911 calls.
Did you want an exam date?
Yes, Your Honor. In-person exam, please.
Okay. Are there any concerns regarding bond that would affect the timing of an examination?
No concerns from the people at this time, Judge.
No concerns from the defense, Your Honor.
Okay, can we have an October date, please?
Okay. How about October 19th at 9:30?
October 19th at 9:30, does that date work?
Yes, Your Honor.
Okay, October 19th at 9:30 it is for an in-person examination. Please make sure, Mr. Chappie, that you are present in the courthouse as opposed to being on Zoom, and that you afford yourself enough time to pass through any screening before coming into the building, as it may cause delay. And my expectation is that you'll be here and ready to go when the case is called. Bond will continue. Please make sure you adhere to the no contact provision in place. Not directly or indirectly is there to be any contact. And we'll see you on October 19th.
Thank you, Judge.
Thank you, Judge.
Thank you.
Calling parties on Travion Henderson. Calling
Ready.
case number 2158367, People versus Travion Kumar Henderson. Defendant is charged with count 1, carrying a concealed weapon. Count 2, police officer assaulting, resisting, or obstructing. Count 3, weapons, felony firearm. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remand PP 82800 on behalf of the people.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Travion Henderson.
Good morning to you. Is Mr. Henderson here?
Mr. Henderson is not here, Your Honor. I ask that we waive his presence for this proceeding.
So ordered. What's your pleasure today?
Your Honor, I have received discovery on this matter. I'd like to set this matter for a preliminary examination.
Okay. This is a what, CCW and an R&L. Mr. Clerk, what's the first available?
December 20th at 10:30.
December 20th at 10:30?
Did you say December 20th?
Oh, yeah. I can give you a date next week if you like, but you'll be sitting in the hall and we may have to adjourn it.
Well, I'll take the December 20th at 10:30.
Yeah, but no, and I don't mean to say that in a joking manner. I can give you a date, say in September, but the reality is there is a very good possibility that you'll be in the hallway for quite some time. And at the conclusion of the morning, I may have to give you a new date because we are just overloaded.
Oh, no, Your Honor, I apologize. I don't, it just, the December threw me off, but no, that date is fine. That date is fine. I'd rather have a date certain than a date uncertain. So that the December 20th at 10:30 is going to be in my books.
Okay, sounds good. And again, I didn't mean that in a joking way. I want everyone, and there's always the possibility, Mr. Riggins, you know how it goes.
Yes.
There's a possibility that people come in here and they waive their exam and witnesses don't show. but I think that we've been together on at least one occasion where you were in that situation and you had a non-custodial matter that had to be adjourned at the end of the morning. And I remember you were very, very, very displeased with me. I'm trying to appease everyone and give everyone the dates they want, but I cannot, I really can't, I can't make this stuff up. Our dockets are exploding.
I understand, and I have no issues. The December 20th date is going to be fine, Your Honor.
Okay, in-person exam, December 20th at 10:30, and the discovery has been received. If there's any issue that comes up between now and then, do not hesitate to contact the court, and we'll tee it up for whatever you would like us to do.
Thank you, Your Honor. I appreciate that.
You're welcome. All right, we're all set.
Yeah.
Did Mr. Adams make it back from the breakout room?
I'm bringing him back, Miss Mandarino.
Okay, I just didn't know if we had lost him. Okay.
Mr. Riggins has to take the case, Maldonado, and he's in the county jail with
Is he present right here?
Yeah,
Oh,
we just
you
gotta
caught
have
it.
him
You
switch.
caught it.
No,
Oh,
he's
wait.
not there. They,
Your Honor, if it helps, I can waive Mr. Maldonado's presence.
Okay. Let's call Maldonado, and then we're going to call dates.
okay.
We have Mr. Maldonado, he's here.
Okay.
Thank you. Calling case number 2159406, People versus Rolando Maldonado. Defendant is charged for count 1, home invasion, first degree. Counts 2 and 3, criminal sexual conduct, second degree during a felony. Count 4 and 5, criminal sexual conduct, fourth degree, force or coercion. Count 6, domestic violence. Count 7, illicit destruction of personal property, less than $200. Defendant is scheduled today for a probable cause conference.
Thank you, sir. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Rolando Maldonado.
Good morning. And Mr. Maldonado, could you state your name, sir?
Excuse me, Judge, this is Officer Cotton. He said he needs an interpreter.
That's one of the issues I wanted to bring up with the court, Your Honor.
Oh, I see. Well, I don't know that we have one.
I don't think we do. Your Honor.
Well,
What's going on?
it reflects clearly that Mr. Maldonado is present on the screen coming from Wayne County Jail and is in need of an interpreter, which unfortunately we don't have at our disposal at this very moment. Mr. Riggins?
Your Honor, I had the opportunity to meet with Mr. Maldonado, I want to say last week. And upon our first meeting, I realized that he needs an interpreter. I should have actually submitted a motion and order requesting a Spanish interpreter for Mr. Maldonado.
Okay, you said you did? You did submit?
I did. I think I sent it to Tammy, your clerk.
Okay, and if
And I
that
should have sent a
has,
copy to Mr. Bloomers.
yeah,
I
if
did.
that,
Yeah.
I don't see it. She left some documents for me. She's obviously not here today.
Okay.
That's for me to sign, and as I'm looking through what's on my desk right now, I do not see that as one of them. However, this does sound vaguely familiar. I'm wondering if I received that and signed it, because I do recall eyeballing something from you with regards to an interpreter. Oh, I know what happened, Mr. Riggins. I signed it, but then I handed it to Madam Clerk to make sure that I am the person authorized to approve such an expense. And so she may have sent it up to the presiding judge of this division, Judge King.
All right.
Because if you haven't received it back, she likely forwarded it on.
All right.
So I will double check on that. When we have a break, I'm gonna have Mr. Sanders check to see if Judge King has approved it or if it was sufficient that I sign it, because as I indicated, I did sign it, but then I thought, wait a second, this might need to be signed by the division chief. So I will get back to you on that matter. Certainly, I do understand the need.
All right. And obviously, Your Honor, because of that, I think it's prudent to request a brief delay, at least until I've had an opportunity to discuss matters with Mr. Maldonado. Once we get an interpreter.
Okay. Is it possible? Finish, but I don't know if you were listening. I had received that request. I signed it and then I paused and said, listen, can you double check to make sure that I'm the person that's, because there's the requirements as to who can sign and authorize the cost of such a thing. And then I didn't hear anything back. Is there any way you can check with Judge King? Yeah.
Mr. Riggins, what case are you here on?
Hold on one moment. I'm sorry.
Mr. Riggins, either we can, Mr. Clerk is going to try to check with Judge King on the status of that. Did you want to pass on the matter, or do you want to adjourn this for a week's time and see what we find out?
Your Honor, first, I think my client has a question. But I'd like to be able to discuss the matter. So I would personally like an adjournment, but I think my client has a question. I think he's going to try to ask.
Mr. Maldonado?
Yeah, me go for, I'm living for 3 years in this house, and I got one baby, the 8 months, and 1 year, 8 months, and my wife no answer, and me go, and my wife call the police, but I know only me go and me open the door.
Maldonado.
Pero I don't go no more. It's my first time, it's the last time.
Mr. Maldonado, I would advise you not to talk about the facts of the case. All right. If you have a question that has nothing to do with the facts of the case, go ahead. But do not talk about the facts of the case.
Yeah, but I know my home invasion and there's I don't know. It's my house. I got it two girls and
okay.
Yeah. Okay.
Pass matter, or would you like to set this for another PCC?
I need to work and.
Yeah, I'd like to set it for another PCC, in hopes that we can get a interpreter.
Okay, turn off whoever has their YouTube on. Turn your.
We're gonna set another. Yeah, let's set this for today is the 21st. We'll set it, can you return via Zoom on the 23rd? And hopefully we'll have some sort of response. And in the meantime, Mr. Riggins, if you could forward another copy of that to Mr.
Sure.
Sanders,
Yes,
and just to make sure that it didn't get shuffled to the side.
sure. What is your email address, Mr. Sanders?
He put it in the chat,
I
if
want to
that's
do it.
okay.
I want to put it in the text.
He's putting it in the chat right now.
Okay.
And then is the 23rd available for you to return?
Just one moment.
Do we have anything else?
Yeah, I can be here via Zoom, yes.
Brian Brown?
New PCC, July 23rd at 8:30 via Zoom. Mr. Maldonado, we're gonna see you in 2 days. We're gonna see you in 2 days, hopefully.
Yeah, and I have a question. I need a word for work and put in something in my feet, and I need a work and I need to pay my apartment. I need a work and no more. I don't want no more for house my wife and it's my first time and the last time. I need a work for work and I don't want no more. I need a work and need to pay my new apartment. But I don't want no more.
Who's the prosecutor in this matter?
This is my,
I'm sorry?
this is my case, Judge.
Have you been in contact with the complaining witness?
I have not the complaining witness interpreter for the exam.
I'm sorry, say that one more time.
I have not been able to have a conversation with the complaining witness, and she will also be an interpreter for the exam.
Your audio dipped out. Did you say she will also need an interpreter? I mean, I think I'm gathering what you're saying, but here's the problem. Madam Court Reporter has to take every word, so I can't just assume that I understand by piecing together the third and the sixth word. So are you saying that she needs an interpreter as well?
Yes, Judge.
All right. So I'm going to make a notation here in the file with regards to that, but the very first issue is that Mr. Riggins needs to be able to communicate with his client. Hopefully we'll have information on the 23rd. Mr. Riggins, again, is going to forward a new copy of that request for interpreter. And is there
Yes,
anything?
Your Honor, I am.
Just check. Just check.
I apologize, Your Honor. I'm between
That's okay.
two rooms.
That's okay. Was there anything further?
Nothing further, Your Honor.
Okay, thank you. Mr. Sanders will look for that request for an interpreter then.
I will resend it, Your Honor.
Thank you so much.
Thank you.
Recalling, can we have dates back in front of the camera, please, Deputy?
Recalling case number 2158346, People versus Levon Terrence Dates. Defendant is charged with 1 count, stolen property, receiving and concealing a motor vehicle. Also calling case number 2062611, People versus Levon Terrence Dates. Defendant is charged with 1 count, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Defendant is scheduled today for probable cause conferences on both matters.
Thank you. And I see Mr. Chambers is here, that we can, I don't know what that is, so, but make sure that we can call that one next, Mr. Chambers. Oh, okay. I just want to say, can you ensure that that's the next case that we call? Okay, thank you. Can I have appearances on dates, please, starting with prosecution?
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And good morning, Your Honor. Bryn Bailey on behalf of the people, P84009 on case ending with 2611.
Muskie case ending in 4-3, I'm assuming, correct? Madam Defense, please put your appearance on.
Nicole Sadi, good morning again, P74238. I represent Mr. Dates, who's present via Zoom.
Please state your name, sir. Okay, Madam Defense was indicating she's gonna make a motion to consolidate the two files. I'm not really sure how that's gonna work since it's two separate divisions. And she wants an examination date. We paused so that you certainly could be here. She's wanted to make this oral motion.
That's correct, Judge. I see it as a housekeeping matter. Mr. Dates has 3 cases in front of this court. I have a large amount of discovery to go through. I do have the same investigator to help me on all 3 cases. In the interest of being open, I have requested for co-counsel or some sort of second chair to join me from the court. I don't know if that will be granted or not on Mr. Dates' cases. As far as my oral motion to consolidate, it is a housekeeping matter. I'm looking at court efficiency. I'm looking at the number of items I have to get together and the fact that hopefully there will be 2 attorneys for Mr. Dates, but as of now on the defense side, there's just 1. I'm looking at, the time wasted, the impact. I know that this honorable court is trying to schedule everything all together on the same date, just in the interest of efficiency. And even for Wayne County Jail to be able to bring Mr. Dates to one hearing and we handle everything in one matter. So for the record, those are my reasons for consolidation, or for my request for consolidation. Sorry, go ahead.
I'm sure the prosecution appreciates your consideration in that regard for their time and energy, but it's 2 different divisions. It's 2 different divisions. And whether it goes with 1 prosecutor or with 2, as it is right now, they're still going to need to do the independent evaluation with regards to the separate charges on the separate files. So it really is a prosecutorial request that would be made. It has no impact on what you're in terms of your workload. If we set it for an examination, as they're both before us, yeah, they'll probably both be on the same date. And the prosecution will present their cases if they've got them.
People certainly wouldn't have any problem with scheduling them both on the same date, but I'm at a little bit of a loss as to what exactly she's requesting. Is she requesting that only 1 prosecutor handle this case?
Actually, I spoke with, I've been consulting just to make sure I'm doing everything properly. And the attorney I consulted with had suggested that there would be a prosecutor overseeing the ones that are overseeing at least the submission of evidence and discussions about that. The other 2 prosecutors, not necessarily taking them off the case.
As opposed to orally talking about this and your reasons why. I honestly, I'm not certain that I'm agreeing that there needs to be 1 prosecutor. There's 2 different divisions. But I certainly am open to you filing a motion, laying out your reasons, and these 2 prosecutors here would certainly need to go back to their supervisors to determine whether or not that action can occur. So if you put it in writing and they acquiesce, have questions, perhaps they can take it to their supervisor and we can proceed intelligently from there. But as for right now, oral motion is denied. Did you want to set it for an exam or another PCC?
Both. Nope, live exam, please, on both matters.
Okay, Mr. Dates is in custody. Mr. Clerk, can you secure a date? I know we don't have a date, but can you find out what is the best date that we can fit the week of August 9th?
Your Honor, I do want to let you know I will be available for the first 2 weeks of August. I appreciate that Mr. Dates.
Now, the defendant is in custody, so I'm assuming you have someone that's standing in, right? Because with matters where individuals are in custody, I'm not really sure that rises to the level of holding off on an in-custody defendant matter.
I suppose so, Your Honor.
Okay, so the week of August 9th, could I trouble you to tell me what is the least? Oh, strike that. I think we're gonna need it. How many proposed witnesses?
Your Honor, I'm looking, well, Your Honor, it's actually me. I'm looking at 2 to 3 witnesses. Given that I also need to go on the record for something.
Your Honor, I believe at least 3.
Okay,
possibly
so,
4.
Mr. Clerk, could I trouble you to find a 1:30 exam that is not a homicide? The week of August 9th, which I don't know that you're gonna be able to do, or not in custody. We cannot bump a custodial matter. And to be quite honest with you, I don't think we have an opening from my memory until September 3rd, but for an afternoon. But if you could let me know if there's a non-custodial matter the week of August 9th at 1:30, any day, August 2nd through August 13th. And if not, then we go to the next week.
I need to go to the next week. All the ones that I'm seeing so far are all in custody.
Okay, the week of August 16th.
I'm already in the week of August 23rd. The 16th is full too. The week of the 16th.
Okay,
And it has to be an afternoon?
it has to be an afternoon, there's too many witnesses.
Okay. I have on August 26th, it's a 2-bagger.
I can't adjourn a 2-bagger. Is it in custody? I think, is that the one with 1 in custody and 1 out?
They're both out of custody.
What's the charge?
8.
And, but, are you, Mr. Clerk, are you sure both of them are out of custody?
They were just here a couple of days ago.
What's the name of it?
Chambers and Johnson, Joseph Johnson. It was a case, Mr. Clements and Mr. Royal did a motion on Monday.
And that's August 26th?
That's August 26th.
Is there availability August 26th at 1:30? Ms. Lusky and Ms. Sadi?
Yes, thank you. Absolutely.
Okay, so I need you to contact those attorneys and the corresponding prosecutor and have them zoom in so that we can. For some reason, Mr. Clerk, I feel like one of those defendants is in custody though.
I remember specifically both of those
They're out?
defendants were on Zoom. Both they were out.
Can you have the council zoom in so that we can secure a date?
But before we do that, well, let me check one more date. Before we check one.
Your Honor.
Yes, ma'am. One of those defendants is in custody though.
I remember.
Yes, ma'am.
Your Honor, I'm sorry, this is Attorney Lori Morales Smith.
Okay. Good morning. Good morning.
Yeah, I'm sorry to interrupt, Your Honor. I just wanted to point out that I am the APA, I'm DeVoy and Johnson. And it's the second, it's the 26th is the reserved day.
Okay. Thank you. We're gonna need to have the prosecutor and defense counsel zoom in so that we can have a second secured date, if that's the case. Is the 26th available for you, Ms. Sadi? I think you said yes.
Yes, and thank you for the accommodation.
Mr. Slusky and Ms. Bailey, the in-person examination is going to be August 26th. If you need to have one stand in for you, please make sure that you do so. August 26th at 1:30 for
Okay, I'll
both,
be there.
for both of these files.
Yes, Your Honor, I will let the court know if that date is unavailable for my witnesses. But I do, however, have another matter that needs to go on the record for the case that the general warrants prosecution is handling.
Okay, please proceed.
Your Honor, at this time, the people are going to be placing both the court and Ms. Sadi on notice that we are filing an amended complaint and information in this matter, adding counts 2, 3, and 4. Count 2 is going to be weapons, felony, firearm. Count 3 is police officer assaulting, resisting, obstructing. And count 4 is going to be another weapons, felony, firearm.
Okay, please make sure if that is the case that a first amended is provided to Madam Prince. Have a question?
Yes. Mr. Dates, if it's not about the case, you can ask your question. If it's about the case, I will be coming to see you tomorrow. Okay, and
Nothing. All right, I'll just ask you tomorrow. I thought, don't I got court tomorrow?
yes, they're gonna Zoom you in at 1:30 again.
So all right, that's all I want.
Thank you. And I had a question. Should I put in another request on evidence.com, or is there additional evidence you're gonna send me for the other counts?
No, I believe that the information that you already have provides the probable cause as well as any additional information to establish those counts.
Okay, I'll look for the amended complaint, and for the record, I do agree to electronic service.
Thank you. All right, with that being, Mr. Chambers is no longer in the courtroom. Just what matter do you have?
She's on Montgomery. Mr. Chambers.
Is this the individual for Mr. Chambers?
Yes,
Officer,
ma'am.
can you bring him out, please?
Yes, ma'am. Calling case number 21-58505, People versus Michael Ricardo Montgomery. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to great bodily harm, less than murder or by strangulation. Count 3, weapons, firearms, possession by felon. Counts 4, 5, and 6, weapons, felony, firearm. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for an examination. Also calling case number 21-00030, People versus Donovan Barker. Defendant is charged with count 1, contempt of court. Defendant is here today for a hearing.
Thank you. Appearances, please.
Good morning, Rhonda Hadar for the people, P84161.
Good morning, Neighborhood Defender Service of Detroit, Alexandria Pool, P83670, Mr. Michael Montgomery.
Good morning, Judge Arnie Chambers on behalf of Mr. Parker, P63956.
Okay, thank you. And could you state your name, sir?
Michael Montgomery.
Tell me what we're here for today.
Judge, this is a date and time for a preliminary examination, and the people are unable to proceed. As you stated, Mr. Barker, I believe you're going to hold in contempt of court, but Mr. Barker, this court issued a witness detainer for Mr. Barker. He's failed to appear today, and the people are requesting that Mr. Barker be held in contempt of court and court adjournment in the matter until Mr. Barker is located.
Oh, I'm sorry, you're asking for this in custody matter to be adjourned?
Yes, sir.
And so when? Just in.
I can't say for certain, Judge. Mr. Barker was a necessary witness in the case. If this court remembers, the people requested a material witness detainer to be issued. The court issued that. Mr. Barker was located and brought to the court at the date and time for the last exam, which was on June 30th. I'm sorry, on July 7th. And the court released Mr. Barker on a $5,000 bond, personal bond. And then Mr. Barker was subpoenaed to appear before court today, and Mr. Barker was served on July 14th. 2021. He was given notice to appear. As of now, his phone is off. Mr. Chambers is here. It's my understanding Mr. Chambers hasn't had any contact with him.
Judge, if we were here last week, I believe, Mr. Barker doesn't want to testify. That's what I know. I have not had contact with him since. I mean, he's the one that has to live out here. You know, and I'm not suggesting that this particular defendant has threatened my client, but my client has to live out there. You don't live in our secure areas or in our suburbs or wherever it may be. So I haven't had contact with him. He's indicated to the court he doesn't want to testify. I don't know where he is.
Okay, well, I just want to perfect the record a little bit because on July 7th, you indicated that I released him on a $5,000 personal bond, which I did, but that was on the prosecutor's motion.
Yes, Judge. I understand.
So I don't want it to appear as though I issued a witness detainer. He was brought in, and then on these very serious allegations for which the efforts were made to secure his presence, I then subsequently said, okay, you're now released. There was a motion by the prosecution after there was, I'm assuming, a level of comfortability that was reached that Mr. Barker would return to testify. That obviously is not the case, as Mr. Montgomery stands before the court here, and today is the date and time set for an examination. I know Ms. Poole hasn't even spoken yet. I would imagine what she's going to ask for is a motion to dismiss. What I'm struggling with is that while I understand your dilemma, to hold an in custody individual for a ambiguous period of time is not so certain that that is making the best sense.
Well, Judge, oh, I'm sorry, go ahead.
I just made this put on the record. I am moving to dismiss this case because this is the third time that it's on for preliminary exam. He did not show on the first day. Let's hear on the last day on the witness detainer if he was released, and he's not here. My client, as you know, is in custody, and so that's why we're moving to dismiss.
And when I say it doesn't make the best sense, what I'm really saying is that I have to have a basis in order to adjourn a matter. There has to be good cause shown. And now that we're back here again, and the witness that was picked up, brought before the court and released on the prosecutor's motion, which I acquiesced to and signed off on, there is no indication on this record that, well, that witness is going to appear in an hour, or he's being picked up, or that witness will appear here on the 23rd. Without anything that is more concrete, the good cause is I'm struggling to find it here.
Judge, at this point, I submit to the court that the people do intend to ask the Detroit Police Department to arrest Mr. Barker, and the people would ask for at least a week to secure Mr. Barker. And at that time.
And Your Honor, I was just, I mean.
We've been here before though. We've been here before though, right? And so that's my concern is that, I'm sorry, Ms. Cole, I didn't mean to cut you off. My concern is that we've been here before. And there's no indication that Mr. Barker is going to be reachable. Or is it?
At this time, I can't say for certain. I know my officer in charge was able to make contact with him on the 14th and able to serve him on that day. As of now, I haven't been able to make any contact with him. But I know that the Detroit Police Department will certainly do their best to locate Mr. Barker and bring him to court. At this point, the people did not anticipate Mr. Barker to fail to appear, especially with a personal bond out for him and with representation from Mr. Chambers.
I'm not going to adjourn for a week. The prosecution does not have their witness that is, I'm assuming, a necessary witness in this. see the defense counsel and Madam Prosecutor. It's more so with regards to Montgomery, but you certainly can approach as it relates somewhat to Barker. We are back on the record in the matter of People versus Montgomery. At the end of the day, the prosecution is unable to proceed at this particular moment, which is the date that this matter was rescheduled for an examination so that their witness could be here. Their witness is not here, that being Mr. Barker. So what I am going to do is grant defense counsel's motion to dismiss. Here's the really important aspect for you to understand, Mr. Montgomery, because 90% of the time, people hear the word dismissal with all of the bells and whistles surrounding it, and they don't care about the rest. So I'm going to take just a few ticks of the clock to explain to you that it's dismissed without prejudice. And what that trailer language means after the word dismissal is that Madam Prosecutor can go back to her office, and before the ink dries on this dismissal, she has the capability to actually reissue the charges, which I know sounds probably a little confusing unless you're already familiar with it. So if you have questions about the how, the why, and the parameters of that, please make sure you speak to your attorney and she'll explain it to you in greater detail. But the prosecutor seems pretty intent on this matter. So the expectation that there's a reissuance is probably a little higher than other matters. In fact, you could do it so quickly that you might not even be released. I just want you to understand the fullness of that. That the process would have to start all the way from the beginning again.
I understand.
Okay. That being said though, today is the date and time set for the examination. And the prosecution is unable to proceed. I'm going to grant that motion as I indicated for a dismissal. Matter is dismissed without prejudice. And that leaves us with the issue of Mr. Barker. What is your pleasure, Madam Prosecutor?
I mean, the people are requesting that Mr. Barker be held in contempt of court for his failure to appear under court order.
It is currently, this matter was set for
9:30.
9:30? Yes, this matter was set for 9:30. It is currently 10:11, and the defendant, Mr. Barker, has failed to appear. For the record to be perfected, are you asking for a habeas to issue?
Yes, Judge.
Please mute your microphones if you can. Habeas is going to issue as it relates to Mr. Barker. There was a $5,000 personal bond previous to today. That bond is going to be revoked. New bond, what are you seeking?
I mean, I guess it'd be remanded. At this point, I can't give a number amount.
I would just note, Judge, he's not a threat to society. He didn't show up to court today, but he's showing a threat to society.
Bond is going to be set at $10,000 cash or surety.
Okay, thank you, Judge.
Plus a 10% provision.
Thank you, Judge.
Okay, thank you.
Thank you, Judge.
Have a good day.
You too. All right.
Calling parties on Terrence Adams.
Oh, Ms. Poole, I need your signature. I need your signature.
Calling case number 21-56215, People versus Terrence Adams. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Count 3, interfering with the crime report. Defendant is a habitual offender. 4th offense notice. Defendant is scheduled today for a probable cause conference.
Appearances, please.
Jacob Bloomers on behalf of people.
Good morning, Maria Manarino, P39531, on behalf of Mr. Terrence Adams, who joins us via Zoom technology from the Michigan Department of Corrections.
Please state your name.
Terrence Adams.
Thank you. What's your pleasure, counsel?
This is a probable cause conference date. We are requesting a examination date, and because Mr. Adams is in custody, we'd ask the court for its first available date.
Okay. You want an in-person examination?
Yes.
Okay, with that being said, Mr. Bloomers, what is the time frame that you need in order to effectuate an in-person transport?
Oh, is he, I'm sorry, he's in MDOC?
Where is he exactly? I just know that it says ARF hearings, South.
Where are you physically located, Mr. Adams?
Adrian, Michigan.
Okay, so then I'm gonna need the full 14 days.
Okay, today is the 21st. So, Mr. Clerk, can we have a date the week of August 9th?
Okay.
Does he need to, do you know if upon transport, is there a time frame that he's quarantined when he gets here?
I think that's part of why it's longer for 36. Is
Okay.
because 36 is processing.
Okay.
Is why theirs is longer here than everywhere else.
Can I have an exam date in the morning, the week of August 9th?
Yes, ma'am.
I know there's not much space, but it's gotta fit somewhere.
Yeah. August 10th at 9:30.
August 10th at 9:30, Ms. Manarino?
I have a 10 o'clock in federal court that morning.
Okay, another date?
August 13th at 9:30.
Does that date work? August 13th at 9:30?
Yes, that date works for me. Perfect.
Perfect. Okay, we will see you then. Mr. Bloomers, if you encounter any problems with regards to effectuating that writ, please alert us meaning the court and Ms. Manarino.
Yes, Judge, and I just want to make sure it's August 13th, 9:30.
Yes, sir, Friday the 13th?
Oh.
Is it? Yeah, sure.
And then, if we are concluding this, I do have another quick matter with Ms. Manarino, which is a 10 o'clock exam that.
Mr. Clerk?
It's Robert Jones. Jones? Yeah.
Are we able to call that now? That'd be great.
Yes, ma'am.
Oh, thank you so much.
Calling case number. Calling case
Mr.
number
Adams,
one.
we'll be in touch, okay?
All right, so I'm done?
Yep.
Can I ask you a question though, when you gonna contact me?
I'll contact you.
All right.
I've got my clerk working on setting up a phone call right now.
All right, thank you.
Thank you.
Calling
Sorry.
case 60744. First is Robert Jones, second. Defendant count 1, home invasion. 3, count 2, malicious destruction of a building, less than $200. Count 3, malicious destruction of personal property, less than $200. Count 4, domestic violence. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Maria Manarino, P39531, on behalf of Mr. Robert Jones, who joins us via Zoom technology and consents to proceeding via Zoom. Is that correct, Mr. Jones?
Yes, ma'am.
Thank you. Please state your name.
Robert Jones II.
Thank you. Today is the date and time set for a Zoom exam.
Yes, Judge.
Counsel, Mr. Prosecutor.
Well, it actually was set for in person, but we had a discussion prior to.
Okay.
At any rate, the complaining witness, Angela McLean, is not present in the courthouse. She was subpoenaed to be here for a 10 a.m. exam. This is actually the second exam date. The defendant was previously caveus back in November. The complaining witness also did not show to that date. Without her presence participation, we were unable to report this time.
Okay, is there a motion?
There is. We would move to dismiss. Mr. Jones would like me to indicate to the court, however, the earlier caveus was due to the fact that he was very ill with COVID, and we are thankful for the dismissal of this case. We believe and have been saying all along, it's a case of just a mix-up of the names of Robert Jones. This is not the Robert Jones who was involved in any altercation with this unknown complainant.
Yeah.
Oh, my goodness. Okay, thank you for adding that. It might be a good idea for, well, I know you've advised him accordingly with regards to making sure there's nothing else out there pending under that same circumstance. So with that being said, this matter is dismissed without prejudice. And Ms. Manarino, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, thank you.
Okay, you're welcome. We will get a copy of this off to you in just a moment. Once it's been processed, prosecution will also get a copy of this order of dismissal. Mr. Jones, I'm going to assume you did not have a GPS tether attached?
No, ma'am.
Okay, thank you. Well, we're all set here. The matter is dismissed without prejudice.
Thank you, Judge.
Thank
you.
And,
All right, you're all set, Mr. Jones.
Thank you.
You're
gonna call me? Okay.
Looks like another exam, but I had a 9:30 Zoom exam and all the parties are present. And I just wanted to, if I could ask, Ms. James, are you present?
I am.
Okay, my complaining witness is here on the Zoom. Is this gonna be a hold or a waive?
Yes, a hold.
Okay.
Mr. Clerk, whatever we hear from us.
And then, can I just get a breakout room with Crystal Brooks? She's been complaining with us on that.
Okay, so we're calling this right here. Oh, I saw you looking that way. I just wanted to make sure you weren't calling something on there.
Makes sense.
Calling parties on Adante Coleman. Calling case number 20-61753, People versus Adante Ardenaro Coleman. Defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, stolen property, receiving and concealing. Defendant is a habitual offender. Fourth offense noted. Defendant is scheduled today for an examination.
Thank you. Appear.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
And good morning, Your Honor. Good morning to your staff, please, most honorable court. I'm the master, P74485, appear on behalf and with Mr. Adante Coleman, who also appears standing behind me to the right. Sir, please identify yourself for this honorable court.
My name is Adante Coleman.
Thank you. Is this going to proceed to an exam today?
Your Honor, the people are prepared to proceed, but as I understand, the defense will be waiving as to count 1 and the people will dismiss count 2.
Is that true?
That's correct, Judge. We're in the active process of trying to negotiate this resolution. People have offered dismiss count 2 and we will continue to negotiate at the circuit court level. I've advised Mr. Coleman of his absolute right to hold a preliminary examination. He understands that at a preliminary examination, the burden.
Well, I'm going to repeat all of that, but go ahead.
Okay, well.
I just don't want you to think I'm going to go through all of that, so I didn't want you to waste your time making that whole entire representation when I'm going to ask him the same thing.
Absolutely, Judge. I've explained to him his rights, and he wants to waive his preliminary exam to have myself and the prosecutor work this out at circuit court.
Thank you. There obviously no objection to this proposed waiver. Sir, do you understand the allegations against you?
I do.
Do you understand you have a right to a preliminary examination?
Yes, I do.
Do you understand if an examination occurred, the prosecutor would need to establish by probable cause standard only? Crimes were committed, city of Detroit, county of Wayne, and they probably committed the crime. Do you understand that?
Yes, I do.
And if at an examination, the prosecutor were able to meet that burden, the matter would then be bound over. Do you understand that process?
Yes, I do.
So the representation made by your attorney is that you wish to waive, to give up your right to preliminary examination. Is that true?
Yes, I do.
And do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings
Yes,
without the benefit of an examination at this phase?
Yes, I do.
And is that what you still wish to do?
Yes, ma'am.
And are you doing so voluntarily?
Yes, ma'am.
With that being said, I need the examination waiver form executed. It will be handed up to you in just a moment, which basically indicates what I just said to you on the record here. But if you have any questions, please don't hesitate to ask Mr. Coleman. I do find your waiver to be knowingly and voluntarily given. Matter will be bound over to the circuit court for further proceedings with an AOI date of August 11th at 9 a.m.
Thank you, Your Honor.
And count 2 will be dismissed without prejudice. I'm going to forward that up to you in just a moment, Mr. Slusky, for your signature as the moving party on that. Yes, Mr. Nasser.
Oh, no, not. Thank you so much.
I'm checking off the box at the bottom titled Other. Mr. Slusky, if you would please put verbiage in that would coincide with the reason for the dismissal of count two.
Thank you, Your Honor. For the record, the reason I dismissed count two was it's charged in the alternative. Our office used to charge like that. We don't do that anymore, so it makes sense to me that that's cleaned up to reflect the way that we are currently charging these cases.
This is for Mr. Zaleski. And this is for Nelson.
May I approach?
Yes.
Thank you, sir.
Counsel.
Oh, sorry.
Mr. Clerk, can I have that form back? I just want to add something.
The dismissal?
No, Mr. Nasser's form. I just want to put count one only.
Okay.
Mr. Sanders, that was like this. I couldn't get to it.
Oh, make sure you sign it. Oh. Then the judge will sign it.
Looks like we're having an issue there. We don't need MDOC anymore, do we?
No, ma'am, we got it.
Looks like they're having some sort of emergency. Okay, and do we have Mr. Bloomers here for the examination, the Zoom exam? Was there something? Oh, I'm sorry, was there something further? Was there a second case?
Oh, no,
We're good. Just
sorry.
the paper.
I got nothing.
Okay, you're
What
good.
what
I
do
can
you
come
need?
back for
You
it.
need what paper?
The dismissal for count two.
Once you sign it, I'll give him a copy.
Oh, okay. All right. Thank you.
Sorry about that, Judge.
It's okay, that's okay.
Is Mr. Bloomers in the hallway?
Now, I'm gonna stand under the chair. The chair.
Right this way, ma'am. Is this a hole? Thank you, sir. Okay. No. This is escape, escape. And then I'll call Turk next.
Okay.
Calling parties on Jankia Scaife. Calling case number 1959364, People versus Jankia Sandra Scaife. Defendant is charged with count 1, home invasion, first degree. Count 2, assault with intent to do great bodily harm, less than murder by strangulation. Count 3, assault with a dangerous weapon, felonious assault. count 4, domestic violence. Also calling case number 1958914, People versus Janika Scaife. Defendant is charged with count 1, armed robbery, count 2, larceny, $1,000 or more, but less than $20,000. Defendant is scheduled today for examinations on both matters.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people on the case ending 9364.
Remind on behalf of the people as it relates to case ending in 58914.
Thank you.
And good morning, Judge. May it please the court, Jeanette Hernandez, P68686, here on behalf of Ms. Gates, to stand to my right. Can you please state your name for the record?
Thank you. What is your pleasure here today?
Judge, most of the matters today have been time for the preliminary examination. The defense is ready on all matters.
Prosecution.
Your Honor, this time the complaining witness, Jakira Horton, on the case ending 9364 is not present in the courthouse. They were subpoenaed to be here for 10 a.m. preliminary exam. Without their present participation, people are unable to move forward this time.
Is there a motion on the case ending in ordinance 190599364?
Judge, we will dismiss for the complaining witness still to appear.
Okay, it is currently set for 10 a.m. and it is currently 10:32. I am going to grant that motion. That matter is dismissed.
I'm sorry, Judge, count 4 is a misdemeanor.
Oh, thank you, thank you. That matter is dismissed without prejudice as it relates to counts 1, 2, and 3. Count 4, domestic violence, is going to be set for pretrial. Mr. Clerk, what date?
That will be August the 11th at 8:30.
August 11th at 8:30 before Judge Garrett, is that?
Yes, ma'am, Your Honor.
Okay, but the felonies are going to be dismissed again, counts 1, 2, and 3. And they're dismissed, I should say, without prejudice, which means it is possible that the prosecution can reissue. If you have questions about the fullness of that concept, please make sure that you speak with your attorney and she will answer your questions accordingly. Madam Defense, on this matter, I do need your signature as the moving party for the dismissal. And as it relates to 190-589-1402.
Your Honor, at this time, the people are not ready to proceed. Our complaining witness, Shatia Curtis Bell, was subpoenaed and notified to be in court today and has not showed up.
The defense will dismiss without prejudice.
Mr. Clerk, I have Eugene Archer. I was told to be on. It was adjourned from yesterday by the court.
Thank you. Just one moment, please. We're in the middle of a hearing. If you
I
could
apologize.
on that matter, and I'm preparing the other dismissal. On case number 190-589-14. Based on the representations that have been provided, the matter is going to be dismissed without prejudice. And that will be dismissed outright as the charges on that complaint were all felonies. Do you have on a GPS tether that needs to be removed?
No.
Okay, counsel, I will just need your signature on the second order of dismissal. And we are all set. Again, the pretrial for the remaining misdemeanor is August 11th at 8:30. Thank you, Judge. Thank you.
Gracie, I'm bringing them in.
Thank you, Officer Williams.
Any silence?
Can you call Eugene to talk to real quick? Or do I have it?
I think you have a copy, yes.
Recalling People versus Eugene Archer. This is 2061175. The defendant was scheduled to appear here yesterday for an examination. Count 1, assault with a dangerous weapon, felonious assault. Count 2, assault or assault and battery. Defendant is listed as an habitual offender, third offense notice. Appearance, please. Appearance, please. Is there a prosecutor? Ms. Yafupi, it is a general warrant, so I don't know if Ms. Bailey.
I believe Ms. Bailey was handling that.
Ms. Bailey, are you there?
She was on Zoom earlier.
It really is, I don't think it's a complicated matter.
No, Judge.
That necessitates.
Okay, then I'll. Good morning, Your Honor. Remind who's on behalf of the people?
Elliot Margolis, Your Honor, on behalf of Eugene Archer. Your Honor, I realized that yesterday was set for the preliminary examination.
Is Mr. Archer here?
No, he is not here. I tried calling him just yesterday, okay, and this morning I wasn't able to reach him. I previously sent him a letter a couple months ago. However, I must tell you, I apologize to the court. I lost my file Friday, or not my file, my appointment book that had all my court dates in it. So I had to reconstruct my appointment book over the weekend, and I missed this matter. So I deeply apologize to the court. It's never happened to me before. But usually I call, I try to get in touch with the clients the night before, and in this case, I wasn't until after the fact. So I would ask just for another date to be set, and I'll try to get a hold of him by letter again.
Okay, well, it is problematic that the defendant is not here today. Certainly the expectation is that you both would have been here yesterday. I understand you just relayed to the court, and I thought that that was unusual as well, which is why I did not enter a capias yesterday. I wanted to hold off a day to see if we could reach you and get a response from you. So thank you so much for zooming in today. But Eugene Archer.
Thank you.
Eugene Archer should have been here yesterday and should have been here today. So I'm a little hesitant to keep kicking the can down the road when this was set for an examination, but how about we do this? I'll give you until the 23rd, this Friday, July 23rd, and if you can get him on Zoom, I will hold off on issuing a capias. If not, a capias is going to enter.
Okay, that's fine. At 9 o'clock?
8:30 via Zoom.
8:30. Thank you very much, Judge, for understanding my situation. Thank you.
Oh, absolutely. And just to be clear though, the 8:30 on the 23rd is not going to be an examination. We're going to call that a PCC. We're going back to the square. But I'm making a notation. But I'm making a notation to myself that if he is not present, a capias will issue.
I understand. Unfortunately, I'll probably not be able to get him a letter, but I'll try calling him again.
Okay.
Thank you, Judge. Bye-bye.
Take care.
Calling parties on Don Bracy. Calling case number 20-60759, People versus Don Anthony Bracy. Defendant is charged with count 1, motor vehicle, unlawful driving away. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Yeah, I believe Mr. Slusky is, speaking with his OIC.
Okay.
The only other thing we have ready is the
Let's call it.
Calling parties on Dario Turk. Calling case number 21-55530, People versus Dario Ramon Turk. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, aggravated domestic violence. Count 3, domestic. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Nicole James, appearing on behalf of Mr. Turk.
Okay, Mr. Turk, please state your name.
Dario Turk.
Thank you. Any preliminary matters before we proceed to the Zoom examination?
None from the people, Judge.
Okay.
No, Your Honor.
First witness.
Your Honor, the people called Crystal Brooks.
And for the record, before that witness is sworn in, I do want to state that on February 19th, per my notes, the defendant did waive his right to an in-person examination. So that's why I'm not going to voir dire him in that regard right now. He's already waived his right to a live exam. And your first witness is Crystal Brooks, correct?
Yes, Judge.
Ms. Brooks, could you please state your name? And you have to give me video as well.
Crystal Brooks.
Thank you. And Ms. Brooks, are you in a room by yourself?
Yes, I am.
Okay, that's going to be an important aspect as you testify, that you be in a room by yourself. And if you could also make sure that you speak nice and clearly, because we have a court reporter that is recording everything that's being said. Sounds like your audio is coming through nice and clear. Could you please state your full name and spell your first and last name?
My full name is Crystal Nicole English Brooks. However, my preferred name is Crystal Brooks, and it's KrystleBrooks.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Prosecutor.
Good morning, Ms. Brooks. Could you please state your full name for the record?
Good morning, Crystal Nicole English Brooks.
Thank you. And Ms. Brooks, on or about the date of January 24th, 2021, were you at the address of 23750 Fenkel Street?
Yes, I was.
And is that address in the city of Detroit, county of Wayne?
Yes.
Okay. And were you, is that a house or an apartment?
It's an apartment.
Okay. And who does that apartment belong to, or did it belong to at that time?
The defendant, Dario Turk.
Okay, Dario Turk. And do you see Mr. Turk here in the Zoom gallery today?
Yes.
Okay, could you please tell the court what the defendant is wearing?
Looks like a dark colored polo shirt. I apologize. A dark colored short sleeve polo top. I can't see what he's wearing on the bottom.
Let the record show that the witness identified the person, the defendant.
The record will still reflect the identification of the defendant.
Okay, so Ms. Brooks, when you were at Mr. Turk's apartment on the 24th, did something out of the ordinary happen that brings you here today?
Yes. We got into a physical altercation where I sustained multiple injuries.
Okay, so before the altercation started, what were you doing with Mr. Turk?
We were watching a movie and he had passed out at some point.
Okay, had either of you been drinking?
Yes, he had been drinking all day, and I had about maybe 2 drinks later in the evening, around 7 or 8-ish.
Okay, and so you said he was passed out on the couch. What happened when he woke up?
When he woke up, I was in the middle of packing my things to leave. And he asked me why I was leaving. And I said, because he was a liar and he was hiding something from me. We had a reoccurring issue in the relationship with a cell phone. And I think he was upset about the fact of me leaving. So a verbal altercation ensued.
Your Honor, I'm going to object to speculation.
Objection sustained. And if you could make sure that you, Mr. Bloomers, continue to ask questions, so this moves in a question-answer format as opposed to a long narrative.
Yes, Judge. So, Ms. Brooks, you said you awoke, you were packing your things, and you told him you were going to leave. What happened next?
I took some things down to the car, and then when I came back, he asked me why I was leaving. I told him why I was leaving, and then from there we started verbally arguing.
Okay, so you started verbally arguing. How did Mr. Turk appear at this time?
I'm sorry, you cut up just a little bit. Can you repeat the question?
How did Mr. Turk appear at the time when you started arguing?
He was very upset.
Okay, so you said you were verbally arguing. What happens next?
It then turned physical. He shoved me while we were in the bedroom. I left out of the bedroom and entered the living room to gather more things. The physical. Oh, go ahead.
No, that's it. So, you said you came back to the living room?
Yeah, just to gather more things. Yeah.
Okay. And what happened after you got back to the living room?
He grabbed me by the collar of my shirt, like grabbed me up like this during the time. The chain that I was wearing got broken. There was some hair pulling, and I freed myself from him again to try to disengage and just continue to leave.
Okay. And I'm just going to ask, what was your relationship with Mr. Turk at this time?
We were dating at the time.
Okay. And about how long had you been together?
Approximately 4 months, from October 24th, 2020 to the date of the incident.
Okay, thank you. So after this initial physical altercation happens and you said you broke free, what happens next?
He then got the phone and proceeded to call the police and report that someone was breaking into his home and taking his things, which is not even close to what was going on.
Okay. And so what did you do next after that?
I proceeded to leave, and that further upset him.
Okay. So did you actually exit the apartment that time?
No, I was near the door putting on my shoes. That's where we kept our shoes. So I was putting on my boots. I was at the door and I was getting ready to leave after he called the police.
Okay. And so what happened next?
And when he saw that wasn't going to stop me from leaving.
I'm going to object to the speculation.
Objection sustained.
Okay, so when he saw that I was continuing to leave, he made the comment. Go ahead.
No, I'm sorry. Go ahead. The Zoom does make it a little difficult sometimes. Go ahead.
Sorry. So when he saw that I was continuing to leave, he said something to the tune of, "Oh, that's the way you want to play it. You think you're going to leave," or something like that. And then he went up to his closet, went to his toolbox, and got out a hammer and came towards me.
Okay. So you said he got a hammer. He came towards you. How was he holding the hammer?
He had it in his hand. It was lowered at the time.
At the time, what were you thinking when he came towards you with the hammer?
That he might try to hit me with it.
Okay. And so what happened next as he approached you?
So I grabbed his wrist to stop him from doing whatever he was going to do. And then there was a physical altercation between me and him over the hammer. And I wrestled it away from him, and then I threw it across the room and then bolted.
Okay. And so when you say you grabbed his wrist, is that the wrist that was holding the hammer?
Correct.
And so you say you bolted. Now this time, did you exit the apartment?
Yes, this time I took off running because it had escalated. Yeah.
So after you exit the apartment, what happens next?
He retrieved the hammer, chased after me down the hallway, down 3 flights of stairs, all the way to my car. He caught up with me at my car and then threw me away from the car so that I could not get in and leave.
Okay. So you say he threw you away. Were you still on your feet? Did he kind of push you, or did he throw you?
Well, I was like at the car getting ready to open the door, and he like grabbed me and pulled me away from it and like threw me to the ground. But
Oh, you did fall to the ground.
yes.
Okay. So he throws you to the ground. What happens next?
I get up, of course, to try to get back in the car, and then there's more physical altercation again to keep me from getting into the car. And I was able to break free and reach the car again.
Okay. And I believe you said he had gotten the hammer back. Where was the hammer during this?
I want to say it was in his hand at the time, because when he, okay, go ahead.
Oh, no, continue.
Oh, because when he caught up with me again at the car the second time, he got in the car with me. I was unable to close the door, and he was over me in the car with the hammer in his hand.
Okay, and I see that you're kind of raising your hand. Did he have his arm raised with the hammer?
He did, but we were in the car, so he couldn't get a good raise. So he then put it on top of the car after a while.
Okay, and so what happened after that?
After he put it on top of the car, he then tried to get me out of the car. First by pulling me on my shirt, which is how my shirt got ripped. And then he started trying to like pull my things out of the car. I was holding on to the things in my car so he couldn't pull those out. And then once that wasn't working, he then grabbed my right ankle up underneath his arm and started trying to physically drag me out of the car. And that's when I felt something tear.
Okay. Now, and I just want to clarify, are you in the driver's seat at this time while he's trying to pull you out?
Yes, sir. I was on the driver's side.
Okay. And you say he grabbed your ankle and he was pulling and you felt something tear. What do you mean you felt something tear?
But by this time the police had started to arrive and he let me go. But before then, like while he had the ankle, I felt a severe pain and I could feel something like tear in my ankle. And when he released me, there was a throbbing pain in my ankle.
Okay, thank you. And so you say the police were starting to arrive at this point?
Yes, because he let me go without provocation.
All right, and so what happened as the police arrived?
They approached, they separated us, handcuffed us, and I guess took each of our statements.
Okay. And did you seek any medical treatment for the injuries sustained?
The following day, I went to the emergency room, Providence and Southfield Hospital, for the ankle.
Okay. Did you sustain any other injuries during any of these altercations?
Yes, I had several cuts and scratches on both hands, scratches on my neck and chest, and I had a bloody nose as well.
Okay. And what was the diagnosis of your ankle, if you didn't say it already?
A sprained ankle.
Okay, thank you. No more questions, Judge.
Cross-examination?
Now, Ms. Brooks, you had an opportunity to go to the police station and you gave a statement, is that correct?
No, I never went to the police station.
You gave a statement over the phone?
Over the phone, yes, ma'am.
Okay, you gave that statement to Officer or Investigator Latanya Moses?
Yes.
When she took your statement, did she rush you through it?
No, I don't believe so.
She asked you what happened?
Yes.
she gave you time to explain to her what happened?
Yes.
And many of the things that you've said here today, you didn't tell Investigator Moses when she took your statement, did you?
I don't have a copy of the statement in front of me, but I gave her the highlights, I guess you will.
Now, she didn't ask you for the highlights, right? She asked you to tell her what happened that day, right?
Yes.
Okay, so you're at Mr. Turk's apartment, correct?
Correct.
And he falls asleep, correct?
Yes.
And you take his phone and try to go through his phone, is that right?
Yes.
Okay, and so when Mr. Turk wakes up, he's asking you for his phone, correct?
Yes, he asked me
And
where
you're
his
asking
phone
him
was.
for the passcode so you can go through it, right?
I didn't ask him for the passcode. At that point, I was passing and ready to leave.
Okay, so are we clear that the passcode that you discovered before wasn't working, right?
Yes.
And when Mr. Turk woke up, you were upset because you couldn't get into his phone, correct?
Yes.
Okay. Now, Mr. Turk then asked you for his phone. Am I correct?
Yes.
I'm sorry,
Ms.
Madam.
Jane?
I'm sorry.
Yeah. Madam Clerk?
Yes, the previous answer.
To whether she was upset.
No, the question was, are we clear that the passcode that you, discovered before was? Yes.
You want me to ask it again?
Please.
Okay. The passcode that you previously had didn't work, correct?
Correct.
Madam Court Reporter, we're good?
Yes, thank you.
Okay. And when Mr. Turk asked you for his phone, correct?
Yes.
And you refused to give it to him, correct?
I didn't have his phone. I told him I didn't know where it was.
Okay. And at that point, you tell him to call it. Is that right?
No.
You never told him to call the phone to see where it was?
No, I never said that.
But you were actually in possession of the phone. Is that right?
Not at the time of the altercation, no.
You subsequently returned that phone to his brother. Is that right?
My mother did, yes.
Okay, so you're saying that somehow you were, after leaving the apartment, you were able to get a hold of the phone?
Correct.
Okay. So when you are leaving, when you say you're packing your things to leave, Mr. Turk is still asking you for his cell phone, right?
Sure.
And you're taking belongings that things that belong to him. Is that right?
No, I was only taking my things during the altercation.
You never took any of his personal items. You're saying that's what you're saying?
After the police hauled him away, I did have a key to the apartment. He made a set of keys for me, and I went back in to get some more of my things that I was unable to get. And I also got some things that I purchased for him for Christmas, for which I can produce receipts.
So my question was, did you take things that belonged to him? Yes or no?
I took things that were purchased by me for him.
So the answer to that is yes, you took things that belonged to him. Is that correct?
Purchased by me, yes.
Ms. Brooks, when you are leaving the apartment, he continues to ask for his phone, correct?
He asked me for his phone among several other things, a lot of things.
And Mr. Turk goes and finds a corded phone to plug in, and he calls the police, right?
Correct.
And he tells the police that you're taking things out of his apartment that don't belong to you. Is that correct?
He told the police that someone broke into his home and was taking his things, but that's not what was happening. I was not taking his things.
And I'm not asking about whether he said someone broke in. He said that you were taking things that didn't belong to you, right?
And I was not. That's what he said, but I was not.
And when you, and at that point is when you hurried up and left out the department, correct?
Yes.
Now, Mr. Turk, when you're at the car, he continues to say that he wants his phone, correct?
Yes, but I did not have his phone at the time, and I told him that while he was assaulting me. I kept telling him I did not have his phone.
You were the last person with his phone, correct?
I recovered his phone later. I told the cops where the phone actually was.
Miss Brooks, you were the last person with his phone after he fell asleep, correct? You tried to go through it, right?
Yes, I had it in my possession, yes.
Okay.
To look through.
And so you knew where the phone was, and he was asking you to give it to him, correct?
He asked me where it was, yes, and I would not tell him.
I'm sorry, my video went out for a moment. Now, when Mr. Turk is in the room, he's in the bedroom and he's plugging up the phone and he's calling the police. Do you remember that?
Yes, it was in the living room, not the bedroom.
And did you push him while he was trying to make that phone call?
Absolutely not. We were
okay. You said you didn't. You said you didn't. That's fine. So your testimony is you never pushed Mr. Turk down while you were in that apartment.
No.
Okay. Now, when you before you leave the apartment, why don't you just give his phone back? You know where it is. Why don't you just give it back?
I don't know. I think at the time I was just frustrated that we were having the phone issues. And in retrospect, it was probably a petty move not to give it back. But that's certainly not a reason to assault someone with a hammer.
No, he never hit you with that hammer. Is that correct?
He tried to.
And did you tell Investigator Moses that?
Yes.
Or did you tell Investigator Moses he just sat it on the top of the car?
No, I told her that he was over me in the car with the hammer raised as if he wanted to swing it at me and hit me. But I was fighting back. I wasn't going to just let him hit me.
And you're certain that you told Investigator Moses that?
Yes.
Okay. Did he provide you with a copy of your statement afterwards?
I don't recall.
Okay. Now, after Mr. Turk was arrested, you went back into the apartment and took things out, correct?
Yes.
And even the days that followed while he was in the jail, you went back and took things out of his apartment, correct?
Absolutely not.
Okay, so you never took any cigars or anything like that out of his apartment?
Cigars that I purchased, yes, but I took all that, everything that I took was that same night. I never went back after that night. No.
Okay. All right. And you subsequently returned his phone, correct?
Yes.
I don't have anything further on.
Can you redirect?
No redirect, Your Honor.
Thank you. You may exit the Zoom gallery, Ms. Brooks.
Thank you.
Thank you. All right. Any further witnesses?
No further witnesses, Your Honor.
Madam Defense, do you have any witnesses?
No witnesses, Your Honor.
And is there a motion?
Your Honor, the people move to bind over on all charges and reserve argument.
Ms. James?
Your Honor, we're going to object to the bind over without argument.
Okay, there has been testimony presented here today by the prosecution by way of Ms. Brooks as to what happened on January 24th, 2021. And with the testimony, the court is satisfied. This is a probable cause hearing. There is a question of fact that does exist here, and the prosecution has met that burden. As such, the matter will be bound over to the circuit court for further proceedings with an arraignment on information date of August 11th. The misdemeanor is going to travel along with the efficient administration of justice. Is there anything further?
Nothing from the people, Judge.
Madam Defense?
Nothing further, Your Honor. Thank you.
Thank you. Ms. Yalufi?
Yes, Your Honor.
Could you approach?
Have a good one, everyone.
You too, Ms. James. Good to see you.
Good to see you as well.
Oh, okay, let's do Mr. Slusky's first. Are you the waiver or the adjournment?
Adjournment.
Okay, let's do that one first. And sorry that you got caught behind that exam, but we had to, do what we had before us.
No worries.
Where's Mr. Bracy? Mr. Bracy, case stand. Calling case number 20-60759, People versus Don Anthony Bracy. Defendant is charged with 1 count, motor vehicle unlawful driving away. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And good morning, Your Honor. May it please the Honorable Court, Sophia Curry, P72103, appearing on behalf of Don Bracy, who is President stands for us. Mr. Bracy, please state your name for the record.
My name is Don Anthony Bracy.
Thank you. And good morning. Today is the date and time set for a preliminary examination. Are we proceeding to an exam today?
We are not, Your Honor. I am asking for an adjournment for 2 reasons. There's still outstanding digital discovery that I have requested and still have not received it. Mr. Slusky did pull up the video today and said he was going to email it to me. And also, I'm just finding out today that there's a forensic interview of the 2 children that were in the truck. So the people are looking to, after exam, add, I believe, 2 counts of kidnapping. And so I'd like to have the opportunity to review those Kids Talk videos as well as the other digital discovery that we weren't able to provide.
Okay, well, that makes sense. Can we get that digital discovery to council straight away?
Yes, Your Honor, I can get the body cam immediately. The Kids Talk videos, though, I don't have in my possession. I and the officer in charge just found out about them today. The case was, as you're aware, just charged with the unlawfully driving away. So certainly it wasn't the expectation that there would be additional counts of unlawful imprisonment, which now the defense has placed on notice of. So I would ask, or again, I would, despite being prepared to proceed at the exam today, I would acquiesce to the defense's request so that we could make the body cam and the Kids Talk videos available to the defense.
Thank you. I do find good cause to adjourn given the representations. We just need to select a new in-person examination date, which is easier said than done. Mr. Bracy is not in custody. I think the earliest we could possibly do is going to be in October because we are busting at the seams with in-custody exams. Mr. Clark?
You said October?
Yeah.
Okay. How about October 1st at 9:30?
That's fine.
Okay, October 1st at 9:30 in the morning, in-person examination.
(9:30), Your Honor?
Yes, sir. And we will see you all then at that time, okay?
Your Honor, I have one more question for you.
Yes.
My client has a GPS tether on, and he is asking that it be removed. I'm not quite sure on a UDAA why they would place a tether on Mr. Bracy, but he's been on tether since December with no issues.
Okay, so there's the UDAA. And now the likelihood that a couple kidnapping charges are going to be added on?
Well, Your Honor.
And you're asking for me to take the tether off?
I mean, the fact, without going into a lot of detail, the facts of these cases, a little different than your average alleged kidnapping. There's no weapon involved. I don't want to argue my case now, but Mr. Bracy has not been in contact with the complaining witness, nor with those minor children. He hasn't been in that area at all whatsoever. He maintains contact with me consistently. He's here today. He'll be back on October 1st. He doesn't have a prior criminal history. From what I understand, is speaking with my client. I would ask the court to consider that and consider removing the GPS tether.
Your Honor, may I respond?
Well, you can respond, but again, you know, in reviewing the bond, I have to make a determination about the assurances that the individual will return and also about the safety of the community at large. And looking over the investigator's report, whether a weapon was involved or not, the allegation is that a 4-year-old and a 6-year-old were inside of a vehicle that your client drove away that did not belong to him. Again, these are just allegations, I appreciate that. But even without the allegation of a weapon being imposed, I am not going to eliminate the GPS tether unless what Mr. Slusky is itching to say is that he acquiesces to that.
No, Your Honor, the people are satisfied with the bond as it is. The people would object to the removal of the tether.
Motion to remove the tether is denied. I certainly, as I don't say it often, but this is my policy. If you want an examination date, in a couple weeks, I can give it to you. Here's the only problem. You have to walk into that situation eyes wide open. Meaning, it could be a situation where you come in here and you're waiting all morning, only to get called in at 12:30 for a new date, because the directive from the chief is to handle in-custody matters first. And so that puts those that are not in custody and, it just puts them behind. Non-capital offenses are behind. So it certainly, as you know, could be a situation where you come in here and everybody waves or no witnesses show on the other exams and it's wide open. It's kind of a roll of the dice.
Yeah,
So, I'm willing to do it. If you want an exam, second week in August.
Now, we'll leave the date. Mr. Brady is working, so at least he's not coming here and then having to come back. We'll just leave it and maybe address it again in October.
Okay, and if you find in the interim, you want to bring the motion up again, I'm an open door. And we can set the date sooner, just with that caveat that there's the high likelihood, given how high volume our dockets are, that we may not get to you. So we'll keep it right now for October 1st at 9:30.
Okay, thank you.
Thank you, Your Honor.
Thank you.
Calling parties on Wesley Lewis. Calling case number 20-60031, People versus Wesley Lewis, AKA Anthony Bernard Martin. Defendant is charged with count 1, weapons, firearm, possession by felon. Count 2, carrying a concealed weapon. Count 3, weapons, felony, firearm. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rematch on behalf of the people.
Please quick on Tyrone Baker, here on behalf of Mr. Wesley Lewis, who's present behind me to my right now.
Thank you. Could you please state your name, sir?
Yes, ma'am. Wesley Lewis.
Thank you and good morning. We're here today for an examination. Are you proceeding to an exam today?
Your Honor, I've advised Mr. Lewis of his right to preliminary exam in this matter. He was referred to establish probable cause and how they would attempt to do so in this specific case. Given our discussion, Mr. Lewis would like to waive his right to preliminary exam and it be bound over, Your Honor.
Is there any objection to the proposed waiver?
No objection, Your Honor.
Okay, Mr. Lewis, I just have a few questions for you. Do you understand the allegations against you?
Yes, Your Honor.
Do you understand that you have a right to a preliminary examination?
Yes, Your Honor.
Do you understand that if you exercised that right, and we did hold an examination, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that's what their burden would be?
Yes, Your Honor.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes, Your Honor.
So the representation by your attorney here today is that you wish to waive, to give up your right to a preliminary examination. Is that true, sir?
Yes, Your Honor.
And do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination here today?
Yes, Your Honor.
And is that still how you wish to proceed, sir?
Yes, Your Honor.
Thank you. Are you doing so voluntarily, sir?
Yes.
Thank you. I do have the examination waiver form, which has been returned to the file and properly executed. Thank you for that. I do find your waiver to be knowingly and voluntarily given. Matter will be bound over to the circuit court for further proceedings with an AOI date of August 11th at 9 a.m. Is there anything further?
Nothing from the bench, Your Honor.
Thank you so much. Mr.
Thank
Vickers,
you.
good to see you.
Good to see you, Your Honor. Thank you. No, I apologize for this morning. I know I'm.
That's okay. We're so jam-packed that there is some wiggle room as it relates.
Yeah, and I kind of, but I'm.
We knew you would be here. Good morning, counsel.
Good morning.
How are you, sir?
I'm doing fine, thank you.
Which matter are you here on, Carter?
I have John Carter, 2 cases, Your Honor.
Okay.
Okay.
Your Honor, one's a dismissal, one's a waiver.
Okay.
Calling case number 1960598, People versus John Dion Carter. Defendant is charged with count 1, assault with the intent to beat, rape, bodily harm, arrested, murder by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault or assault battery. Also calling case number 2060056, People versus John Dion Carter, aka John Charles Carter. Defendant is charged with 1 count, carrying a concealed weapon. Defendant is scheduled today for examinations on both matters.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Scoop on behalf of the people.
Good morning, Your Honor. Rodney Strong appearing on behalf of Mr. Carter as to both cases.
Thank you. And could you state your name, sir?
My name is John Dion Carter.
Thank you. All right. So as it relates to 190605998, how are we proceeding?
Your Honor, at this time, the people are not ready to proceed. Our complaining witness, Edward Smith and Angela Larkin, had been subpoenaed and notified to show up to court and have not done so.
Is there a motion?
I'll move to dismiss at this time.
Okay. That matter was set today for an examination at 11 a.m. It's currently 11:28 by my clock. And given those representations, I am going to grant that motion to dismiss. Have we received any phone calls from an Edward Smith or Angela Larkin, Mr. Clerk?
No, ma'am, Your Honor.
Okay, I'm going to dismiss that file. Again, that's 190605998. That matter is dismissed. But Mr. Carter, I want to make sure that you understand that it's dismissed without prejudice. And what that trailer language after the word dismissal means is that it is possible that the prosecution can reissue this matter. And if you have questions about that, the parameters of that, the how and the why that the prosecutor has that ability, please make sure that you speak to your attorney, Mr. Strong, who will explain that to you in greater detail. Okay?
Thank you.
All right. Do you have on a GPS tether?
No, ma'am.
All right. Mr. Strong, as it relates to this matter, I will need your signature as the moving party on this file. Again, the matter is dismissed without prejudice. Moving on to 200600056. What's your pleasure, Mr. Strong?
As to that case, Your Honor, Mr. Carter is going to waive the preliminary examination.
Is there any objection to the proposed waiver?
No objection, Your Honor.
Mr. Carter, do you understand the allegations against you? In that matter, you're charged with count 1, weapons carrying concealed.
Yes, ma'am.
Do you understand that you do have a right to a preliminary examination?
Yes, ma'am.
And with each question I ask, I will need an audible answer. Do you understand that if an examination did occur here today, the burden on the prosecutor would be to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed that crime? Do you understand that would be the burden?
Yes, ma'am.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court. Do you understand that process?
Yes, ma'am.
The representation has been made here today that you wish to waive, to give up your right to a preliminary examination. Is that true, sir?
Yes, ma'am.
And do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes, ma'am.
And is that still how you wish to proceed?
Yes, ma'am.
Thank you. Are you doing so voluntarily, sir?
Yes, ma'am.
Thank you. I need to hand up the examination waiver form that needs to be executed by both defense counsel and the defendant. I do find your waiver to be knowingly and voluntarily given. Matter is now bound over to the circuit court for further proceedings with an AOI date of August 11th. Mr. Clark, if you could hand that to Bill. Thank you, officer.
Thank you. I'm sorry, ma'am.
And I need his signature on this order of dismissal too. Thank you.
Thank you. Did Mr. Tuttle arrive yet?
He did not, just the officers, not even the defendant.
The defendant not here?
No, just the witness.
All right.
Now, just Mr. Tillman.
Yep, he was in line this morning.
So he just say it's coming.
Okay.
Thank you. Thanks, so, Your Honor. Good morning.
Good morning.
Don't you think we got that in an hour or two?
Oh, yeah, how are we doing? What do we have up? 2. Okay.
1:30 and Mr. Tucker.
We have Mr. Tuttles. He's our only remaining morning exam. He was on Zoom earlier.
He was in Ohio earlier.
Oh, no. Wait a second.
Calling parties on Brandon Trevier.
I apologize, can we have less than 5 minutes?
Okay.
His mother is outside, we could just have a conversation with his mom.
Oh, okay.
When do you want both parties to log in on that, the case I was telling you about?
Tomorrow or Friday, whenever they can.
Okay.
Because that's what, the 26th?
The 26th is the second date. They got another date. Like
Yeah.
the 26th was a
Whatever,
day date.
whatever those parties are. I'm just reminding myself of when it is, so we have some time. You know what
No,
I'm saying?
their first date is, wait a minute, that's the second date.
Whoever the attorneys are.
Uh-huh.
I mean, I know that's the second date. I'm not sure if it's, they can come in tomorrow on Zoom.
Okay.
It's, what I'm saying is that it's not up tomorrow.
Right.
So they can come in today if they like. They can come in tomorrow. Just if you could, just say tomorrow.
Okay.
If you can reach them.
All right.
It's just, I don't want to have, I want them all to understand what's going on.
Okay.
Two defense attorneys and Mr. Morales Smith.
Hey, hey, I got a question. I need to enter one. With Mr. Tank. Same way you have, Mr. Leader? Yeah, he's been on the computer. He's testifying there. I never had one like this, that's why I'm asking. I know. I did 233. Yeah, I'll be here. If not, if you call, I'll call you. Yeah. They got one of them, I think, court cases, you know, to Yeah, I'm here. Your Honor, I was looking in this file for the bond dates, and you wrote that the prosecutor was adding counts to the complaint. Did they provide a new complaint? Because I didn't see anything.
They said that they would.
They would, okay, okay,
I think that was Miss Bailey that said that.
okay. Is his client here? Is that what the problem is? His client is here. Oh, he is here? Oh.
She is ill and I'm her caregiver, so I have to watch her. Which one to go all downstairs before we got up here. Yeah. Right here in the corner? Okay.
Calling case number 2056186, People versus Brandon Isaiah Trevier. Defendant is charged with count 1, third-degree arson. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Kufi on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tellers on behalf of my client, that's Mr. Trevier, who stands to my near left arm at this particular, right arm, I apologize, at this particular time.
Could you please state your name?
Brandon Trevier.
Thank you. What are we doing here today?
Your Honor, today time set for a preliminary examination. I've had an opportunity to speak with my client regarding his rights to have his preliminary examination held. After understanding his rights to have this examination held, at which time the people would have to show by probable cause the crime was committed and by probable cause he committed that crime. It is my understanding that Mr. Trevier wishes to waive his right to a preliminary examination, allowing the case to be bound over the Third Circuit Court in preparation for trial. Is that accurate, Mr. Trevier?
Is there any objection to the proposed waiver?
No objection, Your Honor.
Okay, I just have a few questions for you, Mr. Trevier. Do you understand the allegations against you, sir?
Yes, I do.
Do you understand that you do have a right to a preliminary examination?
Yes, I do.
Do you understand that if an examination did occur, the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, County of Wayne, and that you probably committed those crimes? Do you understand that, or that crime? And if the prosecutor were able to meet that burden, the matter would then be bound over. Do you understand that process? The representation has been made that you wish to waive your right to a preliminary examination, to give up your right to an examination. Is that what you wish to do, sir? You need to have a little bit louder, more audible answer.
Yes.
Okay, and do you understand that that would mean that this matter would be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes.
And do you still wish to proceed knowing that?
Yes.
Thank you. And are you doing so, waiving your right to an exam voluntarily on your own? Thank you.
Yes.
Can you hear him?
I can hear you.
Okay, all right. With that being said, I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an AOI date of August 11th, 2021 at 9 a.m. I just need the examination waiver form to be executed. I've handed it up to Mr. Clerk. And defense counsel and defendant both need to sign. Is there anything further, Mr. Tuttles, you wish to address?
Not at this time, Your Honor.
Okay, thank you so much.
Mr. Curry, you don't have one beside it.
We handled Gracie, correct?
Yes, ma'am, we handled everything.
Right?
We handled everything.
Everything?
Yep. This was the last one.
Okay. We just have to register this afternoon. Thank you.
Okay. Calling case number 20-61064, People versus Nathaniel Camille Wimister. Defendant is charged with count 1, carjacking, count 2, armed robbery, count 3, assault with intent to murder, counts 4, 5, and 6, weapons, felony, firearms. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good afternoon, Your Honor. Rima Gupta on behalf of the people.
And afternoon, gentlemen. Good afternoon, Your Honor. Attorney Kiana Franulix, T73015, present on behalf of Nathaniel Flemister, who is also present in the courtroom today for his preliminary examination. Mr. Flemister, can you please state your full name, including the junior?
A little bit louder, sir. Thank you. Okay, today is the date and time set for a preliminary examination. Are we proceeding to an exam?
Your Honor, we are not. I have had discussion with the people, as well as my client, after advising him of his rights to preliminary examination and the burden that would have to be proven in this court. This time, Mr. Flemister has indicated he is willing to waive his preliminary examination and be bound over to circuit court, understanding that the burden is a probable cause standard. As such, I have advised the people as to that, and the people have indicated that they would agree to waive as well.
Okay, no objection from the prosecution?
No objection.
All right. Mr. Flemister, could you please stand up? Sir, do you understand the allegations against you?
Yes.
Do you understand that you do have a right to a preliminary examination? Do you understand that if an examination did occur, if you did exercise your right to demand that exam, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes.
And if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes.
So the representation has been made that you wish to waive, to give up your right to a preliminary examination. Is that true?
Yes.
And do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam at this phase?
Yes.
And is that what you wish to do? Okay, let me just, as a matter of housekeeping, let me digress for one moment. There was a competency evaluation that was done. Report came back, and it is my understanding that the prosecution and defense intended on stipulating to it, but we did not do that because the defendant was not present.
That is correct, Your Honor, and I meant to mention that before I went into the argument for, not argument, but in placing on the record the examination. And also, if I may, Your Honor, there was previously a request for independent competency evaluation from Mr. Flemister, and that date was set by the court. I had further counsel with Mr. Flemister during a jail visit, at which time he indicated that he stipulated competency and waived the independent evaluation and have this matter moved to preliminary examination. I did contact the court following that discussion with Mr. Flemister to have this date set, to have that review moved basically to set a preliminary examination date instead of a review for independent competency review. So at this time, Mr. Flemister is stipulating with counsel that he is competent and stipulated to the findings within the competency report of the Center for Forensic Psychiatry. At this time, waiving the independent evaluation, but also just on record, if that sometime in the future becomes apparent that it does need to be done, I would just make that motion at that time.
Okay, is there a stipulation to the findings of the competency evaluation from the prosecution as well?
There is stipulation, Your Honor.
Okay, that stipulation will be accepted, and this court does deem you competent to stand trial based on that stipulation. And now, pivoting back to the waiver. Sir, do you understand that if you waive your examination, you give up your right to an examination, that has the effect of this matter being bound over automatically without the benefit of an exam here? Do you have a question about that? I noticed you hesitated.
Your Honor, I think it may be the language that the court is using, it may need to be, a little longer.
So if you waive your exam, if you give up your right to an exam, what that means is that the matter is automatically gonna go across the street without an exam. Do you understand that? Okay, is that what you still wish to do, sir?
Yes.
All right, I do find your waiver to be knowingly and voluntarily given. I'm assuming you are doing this voluntarily without threat or coercion? You're doing this on your own? Okay. I will accept the waiver of the examination. Matter is going to be bound over to the circuit court as charged with an AOI date of July 28th at 9 a.m. Is there anything further?
Nothing further at this time, Your Honor.
Okay, anything further, Madam Prosecutor?
Nothing further, Your Honor.
Okay, we're all set.
Our business is scheduled for today, was, yesterday.
Okay. And you have that waiver form back, right, Mr.?
I do, Your Honor.
Yes, fine.
Have a good day.
Continue.